Judge, so it sounds like she missed her blows when she was working. She's clean. I don't know if we can go do a test today to prove that. I did notice that we're set for jury trial on the 25th. The only issue I have with that is I didn't realize that I'm set for an ag assault out of Orange on the 24th. So I would be asking for a reset of that jury trial date. As far as the bond violations today, I've explained to her the importance of.
No, no, we've done this before. This is our third time being back. It's unacceptable. I can't just let her go. Then I become an enabler and I'm telling her it's okay for you to do whatever you want to do. And it's not. You know, if you have an issue, you come up to here, you tell us what it is, and then we can resolve an issue. But I can't just let her go when it's a third violation. No, you're skipping test after test after test after test. This is your third time back on bond violations. It's unacceptable. No. She goes with you. Sorry, you're skipping tons of tests. It's your third time coming back for bond violations. Unacceptable.
Please, my son's graduation is coming. My son's graduation is coming. Please,
I'm not going to talk to you without your lawyer. You scare me. You know, all I asked you to do was not consume while you were on bond, and you were incapable of doing that. You know, the idea is that you learn something. I know that you say yes, I get it, but that you truly learn something, because yeah, this is the first here. How many times has it been in reality? You know, you have to understand that from now on, anytime you get pulled over, an officer will see this. If they smell alcohol on you, what do you think they're going to do? What?
I don't want to take a breath of that.
No.
Go take it in.
Right. That's what's most probably going to happen. And what we're doing today, the proverbial slap on the wrist, from now on, you are facing a minimum of 30 days in jail. The idea is that you learn to where if you're going to endanger yourself, okay, but don't endanger other people. God forbid you make some kind of catastrophic mistake where you're looking at 30 to 40, 50, 60 years, because every day it happens in Harris County. Every day someone dies from alcohol-related collision, and it's not fair when $30 will get you anywhere you want to go with one click of a button, man. You know what I mean?
Yes.
You give up a lot of rights by entering into this agreement today. What you're doing today is you're making a lifetime decision. So don't take it lightly, because once you plead guilty to this offense, there's no turning back. You cannot come back tomorrow, next week, 2 weeks and say, you know what? I changed my mind. I don't want to do this anymore. Once you plead guilty, it will go on your record. It's going to be there for the rest of your life. Do you understand? You give up a lot of rights by entering this agreement, Ms. Gaindo. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, the right to be arraigned, charged, read in open court. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, there's no turning back. Is this what you want to do?
I'm guilty.
Ma'am, I'm going to find you guilty. I'll send you to 3 days in jail. I'm going to give you credit for one. I am going to suspend your license for 90 days. Do not drive until you get a license. Let me make one more thing clear to you, that DWI is huge business in the state of Texas. When you plead guilty to this type of offense, there is a $3,000 surcharge that tacks onto you. And if you don't pay it, every $100 you owe, you sit 1 day in jail. I'm not going to hit you up, but a second DWI, you're looking at $6,000. If you come back with another one, get ready. It's a minimum of 30 days in jail, and you're also looking at potential up to $6,000. Get a clue. Good luck, man. Morning, Mr. Johnson. Mr. Johnson, you're charged with 3 total cases. You're charged with assault of a family member, failure to identify oneself as a fugitive from justice, and criminal mischief. It looks like you've worked out a plea bargain agreement. They're going to dismiss 2 of them. You're pleading guilty to the assault case. You need to understand that this carries many, many consequences. There's an affirmative finding of family violence, meaning that if you ever pick up another case like this again, you will be looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And it doesn't have to be a drag-down fight where you're punching and kicking. No. All you do is squeeze someone's arm and it hurts just a bit. They'll hit you with a third-degree felony. You understand?
Sure.
You can never own a gun or ammunition as a result of this plea bargain agreement today again as well. No more guns, no more ammunitions. You understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
Sir.
How do you plead to the offense of assault of a family member, sir?
Yeah.
I'm going to find you guilty, sentence you to 6 days in jail. I'll give you credit for the 2 days that you've done. Like I said, there's an affirmative finding of family violence. So you pick up another one of these cases. You understand?
Sir.
All right. Good luck, sir. Please see the clerk.
Yeah.
Judge, I have two other things. Mr. Quaylar is set for bond forfeit last week. He's-
No. Okay. That's it.
And then-
5,001. Or no, I think it's more than that.
Mr. White, Mr. President, spoke to Richard. He's wondering if we can, the felon is reset until 3/25. There's already a deal in place that if, that takes care of, then ours goes away.
John?
Is that okay? Yes, sir. No, sure.
Judge, there seems to be an issue with the client coming to court tomorrow. I don't know if his appearance is required,
I
but
can
what we
waive it.
want to talk
It's not a
about.
big deal.
And he wanted me to also address whether or not you would give him another lawyer. I told him that you have a right to request that.
What's going on?
Yes, I just would like to request another lawyer.
The problem is though, is that, if I give you another lawyer, is the same thing going to happen? I don't,
No, we didn't do it. We didn't try it yet, so you can't say that's what's gonna happen. I don't like getting to these things with people because most of the time people are compliant with federal law.
they have their way of doing things, right?
Exactly, I understand that.
And so when you start getting into federal law, this and that, it may become an issue. And that's,
When people come to your court, do you care whether they respect what you're saying or not? No, they just have to follow the order. I have a federal judge's order based off of my life, and she made a decision, and it never gets respected. That's why I'm in here. The laws were violated to get here. And I'm a person too. Federal Carolyn Judge Carolyn Beers, this is her decision. That heard.
what is he alluding to, Mr. D, about this federal decision that,
I have the paperwork. I can show you. I tried to give it to you last time and you said you couldn't accept it, but I have it. I can go get it. for
I
you.
don't get involved with the minutia
I
of,
understand, but it's your courtroom and you're responsible for the court procedures. So I just don't want you and your court to get in trouble because, but I can show you, or I can show him,
no.
but some.
Let's talk to the prosecutor, sir. You can't do that. So
I-
my only issue is understand that if I give you another lawyer now,
Yes.
right, if we end up in the same
No, no.
issue,
You have my word because it's gonna be better communication.
okay, so let's, Vic, let's go ahead and reappoint, okay? I still want to go through the hearing though tomorrow though. So I will waive your appearance for tomorrow. You don't have to appear tomorrow, but you have to meet with a new lawyer now so that you can get the information, so you can get together with whoever that person is. And then I want to continue this hearing tomorrow.
Am I supposed to be here?
Yes, yeah, because you were the one who's privy to this whole thing, right?
I was just informed that you informed someone.
I understand, but I don't think that she understands what the scope of everything is, and I want to get to that.
Yes, sir.
How's jail? Not good, right? We're not asking much. All I'm asking you to do is show up and don't pick up any new cases. You now know you have no one that is going to bond you out. So when you go to jail, you are stuck like Chuck until this thing is over with. Your lawyer has asked for me to give you one more chance. Should I? What are you doing with yourself these days? Why? And where are you living with? Okay, so I have resources for you. We have places that can help you get a job, a phone, a tablet, places to eat, places to sleep. All you got to say is that you want it and we'll try to give it to you. But there's no excuse. That doesn't give you, I get it that you're homeless, but that doesn't give you the right to go in and take some, you know? So don't. All I'm asking you to do is stay in touch with the lawyer that we're giving you and don't pick up any new cases. I will give you another chance, but I'm not going to play this again. You pick up a third case or you fail to appear again, you're going to end up staying with me. Do you understand? Okay. I have Shatoria. She's going to give you a list of places that can help you get a job and places to sleep and food to eat. So there's no excuse. You can always come back here. Whatever you need, come back and I'll give it to you. There's no excuse for you to pick up another case though. You understand? Okay. All right, Anna.
Judge, are we reinstating?
Yeah.
And what about bond conditions?
So bond conditions, so I don't want you to go back to any of the places that you picked up the theft cases from. You're not allowed to go back there. Do you understand? I don't want you to be in possession of weapons as well. As long as you can abide by this and get a job, you and I are cool and stay out of trouble. All right, Mr. Rodriguez,
Yes, Your
you
Honor.
have been indicted on the assault case. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Do you know which case we're talking about?
The first one?
So let me have them read it to you just to give you a bit of a heads up so you know what we're talking about.
Yes, Judge. On December 24th, 2024, the officer was dispatched to location and made contact with the complainant. The complainant stated he followed his sister when she left the house to come get her back, and the complainant ran into the defendant, the complainant's sister's ex-boyfriend, and told the defendant he could not be around the sister. The defendant walked up to the complainant really close. The complainant pushed the defendant to get some space, and the two got into a physical altercation. The complainant stated the defendant bit the complainant's left arm in between the altercation and then ran away. The complainant complained of pain and was advised by EMS to get stitches.
Okay, so I'm going to set you a bond now of 5,004, which is what all the other bonds are at. And then Anna, it looks like the felony case is set for March 11th.
Okay,
You want to do the day after?
yes, and his other misdemeanors are on March 12th as well, so that'll be perfect.
Got it. Okay, so we're going to do it one day after the felony, and then you guys, once,
That's fine.
we're going to try to work a global resolution so that it's all done at once, okay?
Thank you, Your Honor.
Okay, man. So just don't have any contact with the complaining witness in this case and no weapons. I don't know if you're going to
Yeah.
bond out, but those are the conditions on this.
Yes, Your Honor.
case. Okay. Okay.
Judge for Taylor, was that a regular recess? And the state's.
Anna, what do you want to do with Mr. Taylor?
Can we do a regular reset? Because his cases are both fairly new and I don't have anything on them yet.
Okay, so this is Anna. That's the one lower left. She's your lawyer. That's who you need to stay in contact with. If she tell me she can't get a hold of you because you're ducking and dodging and you're out there and you're not keeping in contact, I'm going to revoke your bond. You understand? I'm not asking much. Okay, so he needs to sign conditions real quick and then they can both go back.
Okay, and what day on Mr. Taylor?
How's March 18th through the 20th?
Can I do the 20th?
All right, was that a required appearance?
Yes, please.
I would say yes. Yeah. Yeah. Okay.
There's somebody else back there that has hers also. This-
Okay. Yeah, she knows.
Yeah.
Thank you, Mr. Rodriguez. Okay, guys, take care. All right. So, Mr. O'Quinn, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay?
On November 3rd, 2024, officer made contact with the complainant witness who reported an incident from October of 2024. The complainant witness stated that she and the defendant were in a dating relationship for 2 years and share one child. The complainant witness stated that she and the defendant got into an argument in a car. The defendant pulled over and grabbed the complainant witness by the hair and pulled, causing pain, and then, quote, slung the complainant witness to the ground, causing the complainant witness to have a tooth knocked out and bruises to her face and shoulder.
Okay. Have you spoken to the complaining?
I haven't been able to get in contact with him.
Okay, so Mr. O'Quinn, I'm going to find that there's probable cause to go forward with your case. I'm now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Daruvala as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
So
If you violate this court order, the state can and probably will file a violation of a protective order against you, and it's one of the worst cases you can pick up.
Sure.
I am ordering you not to have any contact and to be in possession of weapons throughout the pendency of this case. Do you understand? As long as you can abide by these conditions, you and I will be best friends. If I find that you're violating it in any way, I'm going to revoke your bond. I'm going to put you in jail. That's it. I will do everything in my power to protect the public. You understand, Mr. O'Quinn?
May we have no threatening or harassing contact? It's, this incident is set to take place in October. They've been,
I don't know because they've not been able to contact her.
that's what is in their report. It says this happened in October.
That I get,
Okay.
but he's not being able to have contact with her and I want to abide by her wishes and I don't know what she wants. Until I know what she wants, then we can talk, but I don't know,
So not right now, you're not able to do anything until they talk to her and then.
Right, I want to know what her perspective is, whether she wants to have contact with you. How do I know that she wants to hear from you? I don't know that. So I always want to honor the wishes of a complaining witness first and foremost. So
And I can just step out real quick and try again just to see if, I get an answer.
it's up to you. I mean, don't rush it. We can always come back later. Well, hold on. We still need to work on the bond. So I don't see any. No. Well, let's do the bond first. So I don't see any prior criminal history. Do you?
Yes, criminal history. He's been here 6 years. His family's here. The child is here.
So you guys have a child together?
Yes.
How many? One or two?
One.
Okay, so I'll set your bond at $100, Mr. O'Quinn. I'll grant you a PR bond. This is the only one that you're gonna get. If I find that you're a danger to my public, you pick up a new case, you start acting a fool in the free world, no more PR bonds. I will revoke your bond. I will issue a warrant and I'm gonna put you in jail. You understand? You've got a great lawyer. Listen to her. She'll take care of you because you have a lawyer. I will waive your appearance. You don't have to waste your time coming to court every month, but you got to stay in touch with her and she'll tell you if and when you have to come back to court. All right. All right. Now we're done with everything that I need to do. So you guys can step back. If you're able to get in contact with her at that point, you guys can reapproach and then we can amend the MOA. But other than that, we're done. All right.
Thank you. Quick approach, Judge. Back on Quinn. I think they were able to speak to the complaining witness.
Yeah, she's able to speak with him. Sebastian was able to make contact with her and he's fine with no threatening, harassing as a condition.
He's in the box.
Come on. So,
And just so we're clear, Judge, I know you mentioned like a 200 feet restriction. And so they spoke
We're
to
good
her
with
about-
removing that.
and so I will take off the residential restriction and I'm going to order you not to any threatening or harassing contacts. Just be careful. Like I said, I don't know what kind of relationship you have with this person, but if you're constantly butting heads, be very careful. You know what I mean? A lot of vindictive people in this life. Got to know who your audience is. Okay, man. Good luck.
Thank
We'll
you.
get it done. No, I don't. Excuses go in one ear and they go out the other. I don't.
That changed. It was something wrong with that device. I got a whole.
They're saying it. There's nothing wrong with it.
I got a whole new one. And I even saw the dude like put it on a new one. It was too tight. I went back to like.
You must charge the thing every.
It was because like it makes like a sound when you plug it in. It says charging begun, and then when you unplug it, it says charging has stopped. And then I called like 2 days before the 10th, the 7th or the 8th, and I told him like it's not making the noise no more. So I wouldn't know if it was charging or not charging or dead or nothing. It wouldn't talk to me no more.
I don't want any more issues.
Sure.
We have any more issues, you and I will have problems. Do you understand? It is your responsibility. No more.
Sure.
All right, take a seat for me. I'll continue it, Rick. Any more?
It was
That's, do
originally on March 6th, because it was December.
you want to keep March 6th?
Yes, Judge, we'll keep that date.
Okay, is discovery complete?
Yes, Judge. Discovery's complete.
Put an offer on the case?
There's a time served offer.
There is now? Time served, okay.
I had people working on it for.
I'll discuss
Well,
with,
they may be working on a mitigation, but. All right, Rick, it's in you. We'll see you March 9th, okay?
that'd be fine, Judge. Thank you.
All right, friend, or 6th, sorry.
Yes, that's correct. Thank you, Judge.
All right, Ben. All right, Mr. Brown, you are charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 9th, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. Upon arrival, officers met with the complaining witness who stated that she and the defendant are married. The complaining witness stated that the defendant and she got into a verbal argument over prior infidelity. And the complaining witness stated that the defendant cornered her and headbutted her 5 times in her face, causing pain.
Any alcohol, anything like that as an allegation?
In fact, Judge, I don't believe so.
Mr. Brown, I'm going to find that there's probable cause to go forward with the case. It appears that a protective order has been issued in this case. Get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. What I normally do is I order no contact and no weapons unless I know that the complaining witness wants to have contact with you. At that point, if they do, I order no threatening or harassing contact, but you have to understand what is threatening or harassing. Doesn't matter what you think is threatening. I could care less what you think. It's what the other person perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it can violate this court order and land you in jail. I don't know what kind of relationship you have with this person, but if it's something where you're constantly butting heads, there's a lot of vindictive people in this world. You got to be careful because you're the one that's on bond for this case. If they call and say, hey man, you're the one that's going to end up. You know what I mean? So those are the conditions now. Are there no threatening or no harassing contact? I'm sorry, no contact and no weapons. I'll have Sebastian reach out to her. If she wants to change it, then you guys come back, let me know, and then that's what we do. All right? Okay, guys. Now, hold on. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him. If he tells me he can't get a hold of you because you're ducking and dodging, or you pick up a new case, or you're a danger to my community, I only have one place for you. You understand? Just all I want, be nice. That's all right. Okay, please.
Thank you, Judge.
Thanks, guys.
On the Melania Smith matter, there's a issue about an extension of her probation.
She sounds like the program judge.
Oh.
They requested a 3-month extension.
Where is Miss Smith?
She's here. Who is that?
Come up, Miss Smith.
The request was sent last week. They wanted 3 months for her to complete IFC SOP. She completed it over the weekend. Ashley granted a 3-month extension. We wasn't sure if they want to wait or. He's supposed to get off probation March 1st, but she owes $325. So we're waiting to see now if she wants to continue the extension or just allow her to.
Have you paid that money off?
Yeah, that I just looked at was $240 and recently, like in the last 20 minutes, just paid that.
Oh, great. So everything's paid off.
Well, they're delinquent. According to my probation officer, he said if I was in good standing, then everything else, I wouldn't, I mean, there wouldn't be anything else I would actually have to pay. I finished.
I know. I think that you're supposed, I don't know.
He's supposed to get off March 1st. Initially, the extension was requested for IFPS. They said that she's satisfied that they're okay with allowing her to terminate.
Great.
So because she has a $325 balance, they didn't make a decision on a 3-month extension.
But now she's satisfied that, right? So,
I don't see that on my end yet. I can double check.
So why don't we do this? Why don't we postpone it till later in the week? Because it takes so,
$201. I have my bank account that I can show.
no, but it has to reflect in the system though. Don't worry. It's not the end of the world. I'm sorry.
Swear today.
I can waive your appearance. Don't worry about it. You know, but you can be here, right? Because if you've done everything that you've done, hopefully they're satisfied with everything and then we can be done once and for all. If you've paid what you need to pay and you're not delinquent anymore, that was all that was needed for it to happen, right? So hopefully that's sufficient for them to say, okay, we're happy. But it might take like a couple days for it to hit the system. That's the only problem. So why don't we postpone to Thursday? I'll waive the appearance. That way you don't have to miss a day of work. Come back. If they're okay with it, then they dismiss. If not, then we'll, I guess, cross that bridge when we get there.
If it's okay, I can make the appearance on Zoom.
Please, that's why we have it. Yes, absolutely. Yeah. Okay, yeah, so can you email them, Alex, and say, hey, that everything's done, she's paid?
I wasn't understanding, you also, because the amount, I'm not sure, yeah. Yeah, can you forward, yeah.
Just stay in contact with him. That's it. Okay,
We can go and say no more.
yeah,
Okay.
have fun.
This is.
Mr. Guevara, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor, so you are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 90 days in jail with credit for the 29 days that you've done.
Yes.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it stays like this on your record forever. Do you understand?
Yes.
Now he has, that he has 2 open DWIs?
Yes, to your honor, we're dismissing one.
Dismissing one.
Yes, Judge.
Does he have an immigration detainer? Do you know?
I believe he
Yes,
does.
he
Your
has a
Honor.
hold, he
Yes.
said.
Mr. Guevara, is it true or untrue that you had a .15 or above? How do you plead to the offense, or guilty or not guilty?
Guilty.
Fine, you go. I will send you to the 90 days in jail. I'm going to suspend your license for 1 year. Do not drive. You know, from now on, whenever you get pulled over, an officer is going to look at your record and they're going to see DWI, DWI. If they smell alcohol on you, the next time you get pulled over, it's probably not going to go well for you. A 3rd DWI, you're looking at a 3rd-degree felony, up to 10 years in prison. Do you understand? Get a clue. Good luck, Mr. Guevara.
Thank you, Your Honor.
All right, you are Mr. Nieto. Mr. Nieto, you are charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 14th, 2025, the officer was dispatched to a disturbance family call at a residence in Harris County, Texas. The officer made contact with the complainant, who stated the defendant had already left the location and was down the street wearing a black sweater and blue jeans. The officer made contact with the defendant, who matched the description. The complainant stated she was washing dishes when she received a phone call from the defendant, who wanted to celebrate Valentine's Day with her and that he was coming over. The complainant noticed when the defendant arrived, he had already been drinking alcohol and brought over a new bottle of tequila. The defendant entered the residence, drank the entire bottle, and started belligerently yelling about his ex-wife. The complainant asked the defendant to leave. The defendant refused, and the defendant started breaking items in the house and threw a vase at the complainant, which she was able to dodge. The complainant eventually got the defendant out the door, and the defendant then threatened the complainant, stating, "If you don't let me inside the house, I'm going to send someone to shoot up the place." He said this several times. The complainant was in fear for her life, and the complainant is in a dating relationship of 5 years with the defendant, and the two live together.
What are you requesting?
We're requesting a MOAB, Your Honor, and no contact with the complainant.
I see a protective order has already been issued.
There been issued, Your Honor, yes. So we're just wanting to make sure there's one issued. Okay.
So understand, Mr. Nieto, that I'm going to find that there is sufficient probable cause to go forward with your case. As a condition of your bond, I'm ordering you not to have any contact with this person, not to consume alcohol or illegal drugs, and to undergo random testing. The protective order has been issued. I would get to know it. If you do something to violate the protective order, the state can file more charges against you as violation of protective order. If you ever have any questions about what you can and cannot do, you can ask your lawyer and she can tell you what you can and can't do. Just be careful while you're in the jail, as all phone calls are recorded. Anything else?
No, Judge, that's all.
Okay.
We're waiving the bail hearing on both of these. So,
Okay. All right, Mr. Nieto, good luck to you and good luck to you, sir. Okay. Thanks, guys. So you're charged with criminal mischief. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause again. They have the full report now, so we'll find out what happened. Okay.
Loading it right now. Okay. So on Sunday, February 9th, 2025, the officer was dispatched to a disturbance call at a residence in Harris County, Texas. The complainant advised that she was going to a nearby gas station, Circle K, and a man she knows, the defendant, was waving a gun in the air and later pointed the gun at her vehicle. The complainant drove off the premises and called her mother, the witness, and the witness advised the defendant.
her vehicle towards.
Stop.
The defendant advised the defendant to come back to her house, and defending her daughter, she pointed her handgun at the defendant. The defendant advised that he went to the Circle K gas station and that he was carrying an airsoft gun because he was scared. He advised he waved the airsoft gun in the air, but never pointed at anyone directly. The officer detained the defendant and placed him in the back seat of the patrol vehicle. The defendant was cursed at deputies and tried to agitate. The defendant tried to threaten deputies for not assisting him in the way he wanted the incident handled. When he did not get his way, he damaged both rear seatbelts by cutting them with a knife found on his person. And the defendant would start to kick the doors, and bang on the cage. The estimated cost of damage to the patrol vehicle is $250.
Okay. All right, Mr. Mutombo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do you understand? If you violate this condition, I'm going to revoke your bond, put you in jail. No more PR bonds, sir. Do you have the ability to hire a lawyer?
Yes.
Would you like to apply for a court-appointed lawyer?
No, it's actually, I have a lawyer that I can speak to.
You sure you don't want a lawyer?
I would, yes. Let me apply for one. I would like one.
Okay, so I just need a little bit of information from you. Let me take a look at it and then I'll have you talk to someone here momentarily, okay? Just be nice when you're out there. I don't want any issues. I want my public safe. I'm going to do everything in my power to protect my public, all right? All right. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine.
It'd be easier that way.
I just see the one, right?
Sorry, Your Honor.
I just see one.
We only are aware of one. Something on one of the non-official websites said there was an FSGI also, but I'm only aware of one. That's all I have seen on the district clerk's website unless it's changed since this morning.
Do you see anything else, Alex?
John Smith?
Yeah.
Smith.
Do you just see the DWI?
I just said DWI, Your Honor.
Okay. All right. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On February 14th, 2025, at approximately 4:50 hours, the officer observed the defendant operating his motor vehicle at the 2300 block of Rice Boulevard. The officer observed the defendant run a red light and crash into another vehicle and observed the defendant then drive his vehicle from the scene of the crash past the officer. As the defendant was passing the officer observed him in the driver's seat of the vehicle and to be the sole occupant. The officer initiated a traffic stop and observed the motor vehicle from the time of the crash. Following that, the officer made contact with the defendant, and the defendant made a res geste statement stating, "Did you see the guy that hit me?" The officer came into contact with the defendant and noticed a strong odor of alcoholic beverage, slurred speech, red, watery, bloodshot eyes, and the defendant was swaying. The officer ran his information, name, date of birth through NCIC, TCIC, and returned a valid driver's license photo belonging to the defendant. Standard field sobriety tests were asked to be performed, and the defendant refused the test. The officer placed the defendant under arrest and transported him to JPC, where the defendant was read his DIC, to which the defendant refused. The officer then had a blood warrant signed and executed.
Okay. Mr. Smith, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a lawyer. Good job on having a lawyer, because you do. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you when you have to come back to court. If they call on you to take a test, then you must come here to take the test. If you fail to appear, then a warrant for your arrest will be issued. I understand that you're going on a business trip, so you're still not to consume alcohol or illegal drugs. If you get called on for a test, at that point, you'll have to go to a Quest Diagnostics, wherever you're located. Hopefully, he's not out of the country at the time. I don't know how that happened.
Judge, he is planning on, he has tickets to go to, for business, Your Honor, not for pleasure, to go to Switzerland and then London for how long will you be traveling?
I'll be traveling, leaving
Hopefully.
on Tuesday, and then I'll be traveling back the following Friday.
Okay, I don't think it'll be an issue. If
It's
it does,
a
just
week
keep
and
us
a
in the loop.
half, Judge.
Yeah, that's okay. Just keep us in the loop. Just, if you're not, I don't care where you're going.
Yes.
I don't care how big of a business party it is, you can't use.
Absolutely.
All right?
Yes.
Okay, so we'll have you sign a resale Victoria. We'll have you get with Felicia Bunkage, and then you guys are good to go. All right?
Yes, sir. So he has permission to travel.
There's no travel restriction. Just don't drink. That's it. We have tests that can go back quite a ways,
Yes.
so we're going to find out. Right? Okay.
Thank you
guys,
very much, Your Honor.
have fun. You are Billy Chapman. Mr. Chapman, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On February 10th, 2025, at approximately 2:08 a.m., the officers were in a parking lot of Reno's Bar, responding to a disturbance that had occurred at the business. While conducting the investigation, they heard a vehicle rev its engines multiple times, and the officers went to check on an individual inside the vehicle, but before the officers could check the vehicle, it took off at a high rate of speed, recklessly in the parking lot, and the officers called for an additional unit to search for the vehicle, and an officer responded. The defendant's vehicle circled the parking lot and returned to the scene, where the calling officer was able to initiate a traffic stop. The officers observed a strong odor of an alcoholic beverage and red glossy eyes. The defendant was placed into custody for public intoxication due to a miscommunication between the officers, and it was later determined a DWI investigation was needed. Standard field sobriety tests were conducted, HGN 6 out of 6. Walk and turn was attempted, but the defendant could not stand in the starting position and was constantly swaying. For the one-leg stand, 3 out of 4 clues were observed. The DIC was read, and the defendant consented to breath. The results were 0.154 and 0.149.
Is this stop for?
So they responded to a disturbance and they heard a vehicle rev its engine and he took off at a high rate of speed. So then they attempted to get it to reach that vehicle because it took off in the parking lot from what they describe a high rate of speed recklessly. And then it came back and then they make
traffic infraction. High rate of speed is conclusory as well.
Because initially they said the officer said he observed and heard an individual revving their engines, and then they were attempting to check. They were attempting to check inside the vehicle, and that's when it took off at a high rate of speed, recklessly in the parking lot, as they describe it. And then the vehicle circled the parking lot.
All of that is conclusory. All of that.
And I understand, Judge. And unfortunately, we do not have the OR at this time, so we can, if you give us a moment, we can see if there is an applicable traffic infraction.
Yeah, I mean, I'll give you a little bit of time.
Yes, Judge.
But can you give me maybe 30 minutes?
Yes,
We can
sir.
revisit.
I'm gonna run somewhere else. I'll be right back.
Okay, take a seat,
Thank
please,
you,
sir.
Judge.
We'll be back with you here momentarily. I'm going to find no probable cause in your case. You have to understand, they give out DWIs like it's candy on Halloween. Do you know why? We lead the nation per capita in fatalities with alcohol-related collisions. Don't become a statistic. One button on a phone, one button, $30. An Uber will take you wherever you want to go. Use it. All right, take a seat. All right, thank you. Mr. Johnson, you're charged with driving while intoxicated, first offense. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. You're also charged with failure to stop and give information on that one. You're facing up to 6 months in jail and or a $2,000 fine. You are making a lifetime decision today. You are making the decision where both of these cases are going on your record today. You need to understand that these will have severe consequences. And the fact that if you get pulled over, an officer is going to see this. If they come up to your car and they smell alcohol, they smell weed, they smell anything funky, it's probably not going to go well. So don't give them the tools. You know what I mean? It's really easy with one button on a phone. $30 will take you anywhere you want to go with an Uber. It's so much easier, you know? You have to understand that what we're doing today, this proverbial slap on the wrist, I mean, from now on, you're facing a minimum of 90 days in jail on a DWI. Do you understand? All right. You're giving up many rights. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, and give up the right to appeal. So once you plead guilty, it will go on your record. You can never take it off. This is what you want to do. How do you plead to the offense of both of the cases? I will find you guilty and I will sentence you on the DWI to 6 days in jail, credit for the 2 days that you've done. And on the failure to stop and give information, I will sentence you to 12 days in jail, credit for the 4 days that you've done.
Should be 6 and 6.
No, it's 12 4 and 6 and 2.
You didn't see that?
I think it's same thing either way, right?
It's time served.
Yeah, it's time served.
Okay,
It
Donna,
doesn't
I'm
matter.
sorry, I didn't see that on the paper.
You know-
That's my bad.
You're allowed to make mistakes every once in a while, right? But if you continue to make the same mistake, when you endanger other people's lives, there are very serious consequences. There's a surcharge of $3,500 that would tack on this DWI. I'm going to roll it for you today. But you pick up another DWI, it's a $6,000 surcharge. Get a clue. It's not hard. I am going to suspend your license for 90 days. Do not drive until you get a license, and good luck to you.
Thank you, y'all.
All right,
And
Tim.
he can come back here if he needs to get occupational and all that other stuff.
Correct.
Yes, sir.
Yes.
Thank you, Your Honor.
Okay.
Can we both be excused?
Yes, ma'am.
Thank
Good
you.
luck, Mr. Johnson. Mr. Riggs, you're charged with criminal mischief and failure to identify oneself as a fugitive from justice. So on the mischief, you're facing up to 6 months in jail and or a $2,000 fine. On the failure to identify oneself, you're facing up to a year in jail and a $4,000 fine. You guys have worked out an agreement where they're offering you 180 on both cases with credit for the 85 days that you've done. Is this how you understand the plea bargain agreement?
Yes.
You need to understand that both of these cases will go on your record.
Yes, sir.
They will be there for the rest of your life. You can never take them off.
Yes.
You give up a lot of rights. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this, there's no turning back. This is what you want to do.
Yes, sir.
How do you plead to the offense of failure to identify oneself and criminal mischief? I will find you guilty, sentence you to the agreement. From now on, you're facing a minimum of 90 days in jail. Got to be careful. You understand? 95% of the people in there, no self-control. Without thinking, if I do this, what's going to happen? Hence the mischief. You know what I mean?
No.
Good luck. Thank you. Good evening. Tell me what you got.
John Melendez, judge, he's there on a BVR. And I think the GPS device has been, the whole issue has been rectified, but I'm not sure. We can check with PT pretrial services there.
What say you?
Judge, I did reach out to the case manager this morning to see Mr. Melendez did check in on the 10th of February to have the device inspected. It was then from the date of the BVR when we lost cell, that cell was then regained on the tenth. And then, to my knowledge, from the case manager and the device inspectors themselves, they stated that no issues with the charger device were found, on our end.
Where's Mr. Melendez now?
He's-
Come up.
He's there, Judge. Thank you.
Is it operational now?
It's operational as of the tenth when we inspected the device, Judge.
Good morning, Mr. Cuevas. Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Is this a first or a second? Alex,
Your Honor.
True first?
True first, Your Honor.
Okay, so you have worked out an agreement where they're offering you 90 days in jail to be probated for 6 months. You must do a DWI education class, a victim impact panel, and a TRAS. A TRAS is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill those to complete this probation successfully. No drugs, no alcohol, guardian interlock, and 20 hours of community service. A one-time $100 donation to Mothers Against Drunk Driving. You need to understand something, that this DWI is going to go on your record. You will be looking at a minimum of 30 days in jail from now on if you ever pick up another DWI. And just the fact that you have this on your record, you ever get pulled over and you smell like alcohol, it's probably not going to go well for you. So I would never, even if you had a sip of alcohol, I wouldn't get into a car. You're taking a huge risk. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this probation, it's a contract you're signing with us. You either complete it successfully. If you violate it, I'm going to issue a warrant for your arrest. I'll put you in jail and I'm going to bring you back out. You're only going to talk about if you violate it. If you do, you're looking at up to 90 days in jail. Do you understand?
I also would like to point out you're on our part, this immigration law as well, but I also want Mr. Cuevas to also speak with his immigration attorney to make sure he understands if there's any consequences to this plea.
So you have spoken to an immigration lawyer?
Yes.
Great. Do you have any questions? Okay. I'm not going to suspend your license. I don't know what the status of your license is now, but just be careful. If it's suspended, don't drive until you get it back. And you must have liability insurance as well. Okay. How do you plead to the officer? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement, send you to it. If you ever have a problem, just come back. We can always help you. We can always work through issues. Money is never a problem. It's doing the stuff that you say you're going to do and do it in on time. All right. Okay. Good luck, guys.